uh, we are really fortunate today to have Lori Shapiro from Pro Bono Partnership Atlanta. Her colleague, Rachel Epps Spears, has been a presenter before. I think this is the first time Lori has presented, but every time someone from your organization comes, we always have a lot of interest, and you very generously give of your time. We know that there are several, or at least a few of the organizations here are your clients as well. So we're really looking forward to this, and we're really grateful. Just quickly, we are recording this session, and it will be available later. Sarah, is this up on our website, or how do we make that available to people?
I'll link the YouTube playlist here in just a moment for all of the past recorded sessions and future. And we'll be getting that up on the Community Foundation website.
Okay, great. As far as the training today, Lori had said she will present, and then after each section, we'll pause to see if there are any questions. So you can do that after each session. But if you have a really urgent question, put it in the chat, and I'll be monitoring that. And if it's something that we seem to be something Lori would want to answer in the real time, I'll go ahead and interject. But if not, as I said, we'll have separate sections, question and answer after each section. And then we'll stop with about 10, 15 minutes to go, about 9:45 or so, to have a broader Q&A. So just briefly, let me introduce our trainer today is Lori Shapiro. She joined Pro Bono Partnership of Atlanta in July of 2014 as employment counsel. She provides direct legal services to nonprofits, in addition to serving as a resource to the partnership's volunteer attorneys, as well as nonprofit clients. Prior to joining Pro Bono Partnership, she practiced labor and employment law, both as a law firm partner and as an in-house corporate counsel. Throughout her career, Lori has had the opportunity to assist clients with a variety of corporate legal matters, including labor and employment law, employee benefits, intellectual property, licensing, non-compete and confidentiality agreements, OSHA issues, and general contracting. So clearly lots of varied and extensive experience. Her law degree is from NYU School of Law, and she also graduated from Brandeis cum laude with a BA in Politics and European Cultural Studies. She's currently the board chair of the Bremen Jewish Heritage Museum and has also served on many nonprofit boards throughout her career. So again, Lori, thank you very much for being here. Really looking forward to this. Before you begin, Sarah, Josh, Mark, or Melinda, is there anything else I forgot or need to add before we pick it up? No? Okay, I will hand it over to you, Lori. And again, have a great session, everyone.
Great. Thank you so much, Tony, and thank you for inviting me here today. I really appreciate it. I appreciate all your help in coordinating the session along with Josh and Mark and Sarah. So thank you all very much for having me today. It's my pleasure to be here and to have a chance to talk to you a little bit about employment law and about what we do at Pro Bono Partnership of Atlanta. I do want to let everyone know at the outset of this presentation that that all the information that I share with you is for informational purposes. And please don't consider anything that I share to be legal advice. We can't give legal advice in a public presentation. So I just need to say that right from the outset. Before I dive into talking to you a little bit about employment law, let me share some information with you about Pro Bono Partnership of Atlanta. And let me go ahead and share my PowerPoint presentation so you can all see it. We're going to talk about managing employment law risks in the nonprofit workplace. And let's see, there we go. Pro Bono Partnership's mission is to provide free legal assistance to nonprofits in the community that serve the poor or disadvantaged. And the way that we do that is by matching organizations that are our clients with volunteer lawyers. We have volunteers in virtually all of the corporate law departments and law firms in the greater Atlanta area. And those attorneys help nonprofits in the areas where they practice in their daily lives. So we're very excited to be able to provide this resource to nonprofits in our community. In case you're not a client already of Pro Bono Partnership of Atlanta, let me share with you how you can become a client. And what you can do is go to our website, which you can see on this screen at www.pbpatl.org. and you can apply to become a client. To be a client of ours, you have to be a 501c3 nonprofit organization, be located in or serve, we say the greater Atlanta area, we really mean the state of Georgia. We are the only organization in Georgia that does what we do. And so we are happy to serve organizations virtually all over the state right now. You have to serve low income or disadvantaged individuals, and your organization must be unable to afford legal services. So please feel free to go to our website. I'm going to talk about a number of legal issues today, and you can find more information as well on our website, including earlier webcasts that have been recorded and articles that we've written about various topics, not only on employment law, but many other areas of law. I know the slide references workshops. During COVID, we haven't been doing in-person workshops, but we're doing lots of webcasts and podcasts and putting out articles whenever issues of interest arise. So we would be very excited to have your organizations apply for our services so that we can be of more specific and individual help to you. And now let's dive into the topics that we're going to talk about today. And what I'd like to do is introduce you to a nonprofit that's going to provide the framework for our discussion today. So the nonprofit is called Once Upon a Time Incorporated. And Once Upon a Time is a nonprofit that operates child care centers for homeless children in Georgia. The volunteer coordinator, whose name is Anastasia, we'll call her Anna, knows Prince from a prior job that she had. And Anna wants Prince to assist with coordinating the volunteers for a new program that the organization wants to implement. Prince volunteers with the organization for a while, and he helps Anna to recruit new volunteers and to do some scheduling. Anna's really happy with his work, and so she goes to the executive director, Cinderella, we'll call her Cindy, and she recommends that they bring Prince on board as an independent contractor to do work for the organization. Prince works 20 hours a week, and he submits his invoices to be paid. And I know we can't really discuss this with each other as I normally would do, but think about what issues there are that are being raised by this situation. So who is an employee? Should Prince be an independent contractor or an employee? He's working 20 hours a week, and he's working every week, and he's working with the volunteer coordinator to bring volunteers in to work in the child care centers that the organization operates. So let's talk a little bit about what is an employee. Under a law called the Fair Labor Standards Act, an employee is anyone who is employed by an organization. An employee means to suffer or permit to work. If you allow someone to do work for your organization, technically under this law, they would be an employee. And it's very important that you consider, as you're bringing someone on board into your organization, whether that person should be classified as an employee or as an independent contractor. And the potential consequences of misclassifying someone are pretty serious. If you classify someone as an independent contractor and they should be an employee instead, and we'll get in a minute, we'll get into what that means. Your organization can be liable for unpaid employment taxes, interest, and penalties, for unemployment or workers' comp penalties, and for benefits that you didn't provide to that individual to which they might have been entitled. And I will tell you that the unpaid employment taxes, interest, and penalties may be even more serious than you realize in a situation like this, because that is one of the very few areas where individual board members and managers of the organization can be held personally liable for unpaid taxes and interest, for employment taxes. So this is a very important issue and a very important decision that your organization is making. And the IRS, believe me, does not hesitate to go after individuals in these circumstances. The way that this typically comes up and the way that our clients experiences it is the nonprofit might let a worker go because of a lack of funding or for performance reasons, and the worker goes to the Department of Labor and files a claim for unemployment. And the worker often doesn't understand that when they file for unemployment, it is the organization typically and not the government that pays those benefits. The Department of Labor contacts your organization and tells you that they don't have a record of this individual being employed at the organization. And they send you a questionnaire to fill out so that they can determine whether this individual who has been classified by you as an independent contractor should really be an employee. Usually, the Department of Labor determines that they don't qualify to be an employee and that the nonprofit then owes money to the Department of Labor for the unpaid unemployment taxes. We've had clients where the Department of Labor audit of their organization following a determination like this was so substantial that it almost forced the nonprofit out of business. So this is a very, very serious issue. Let's talk about how you differentiate an employee from a nonprofit. An employee from an independent contractor. The test for independent contractor status has become a little bit more complicated in recent months. Historically, the United States Department of Labor has been using a test that they call an economic realities test to determine whether an individual should be an independent contractor or an employee. The historical test has 5 or 6 factors, depending on which court is enumerating the test. And the factors include things like how integral the work that the person is doing is to the business of the organization, whether or not the individual has an opportunity to make a profit or experience a loss based on the work that's being done, what skills are involved in the work that that individual is doing, how permanent is the relationship between the individual and the organization. You know, are they like Prince working every week for 20 hours a week for an extended period of time? Or is this just an individual project where they're working for a certain period of time and then the work is finished? And how much control does the organization have over what the worker is doing? That's typically what the Department of Labor has looked at. In December of 2020, the US Department of Labor issued what they called a final rule that was scheduled to go into effect on March 8th of 2021 that focuses on just 2 factors of that economic reality test, including the level of control over the work and whether there's an opportunity for profit and loss. However, the Biden administration has frozen the implementation of this regulation, and I don't think it's going to go into effect at all. So as of right now, the Department of Labor still has the full economic realities test that it had before. But I also wanted to mention to you that what the administration is looking at going forward is a test that's currently being used in California to determine independent contractor status called the ABC test. Under the ABC test in California, the agency would focus on 3 elements that are similar to some of the elements that have been used in the economic realities test, but very specific. They focus on who controls how the work is being done, whether the work is outside the normal scope of business of the organization, and whether the individual has an independent trade or business of his or her own who's doing the work. So those are the things that you would have to look at in order to determine whether someone should properly be an independent contractor. And I will tell you that in California, that test has been applied very narrowly. So it's if this test is adopted on a national level, it's going to become even more difficult than it has been in the past to be able to demonstrate that someone is properly classified as an independent contractor. So that's something to watch and keep in mind as we're watching what the Biden administration is going to do with regard to this aspect of the law. I wanted to mention because it comes up frequently with regard to unemployment in Georgia, that the Georgia Department of Labor uses a slightly different test, but it's similar to this California test that we're talking about to determine whether someone is an independent contractor. And they really focus on the level of control and whether the person, has his or her own business and engages in that independent occupation. So again, something to keep in mind as you're thinking about the proper status of individuals who perform work for you. The IRS has a different test that focuses pretty exclusively on control, but they look at 20 different factors to determine who is controlling the relationship. And I put up on the screen the IRS's definition of independent contractor and employee. And as you can see, an employee is someone in the service of another where the employer has the power or right to control or direct the worker in the details of how the work is being performed. An independent contractor is a worker who's self-employed and contracts to do a piece of work according to his or her own methods and who's subject to control only as to the end product or the final result. So think about it this way. If someone is working within your programs, like the way Prince is working for Once Upon a Time, if someone is doing work that's very integral to what you do for your clients, that person is likely going to be an employee. If someone is coming in to perform a service for you that is really outside of what your organization normally does, such as, if you need some repairs done to your plumbing, or if you need some IT support, and you contract with someone to come in and do that work who has their own business where they go to lots of different organizations and do the same thing, that person would properly be classified as an independent contractor. Now, it's very important that if you bring on an independent contractor, you ensure that you have appropriate procedures in place to differentiate that person from an employee. And I'm spending so much time on this because it's something that we see very, very frequently with our clients, where individuals who work for the organization are classified as contractors, but really should be employees. And so you want to be sure that you have an agreement, a written agreement between you and the independent contractor that sets out the terms of the relationship. You don't want your employee policies or anything like that that exists within your organization to be generally applicable to contractors who work for your organization. You want to have separate policies and procedures that relate to your contractors. You don't want your contractors to be covered by your benefit plans. And when you're talking about a contractor in the workplace, you really don't want to use the same kind of terminology or references that you use when you're talking about employees in your workplace. This person is an independent contractor, not an employee. If they're not performing properly, then they may be in breach of contract, but you're not taking disciplinary action with regard to them. If you need to end the relationship, then you're terminating the contract or ending the relationship. You're not firing or discharging that individual as you would with an employee. Does anyone have any questions about independent contractor versus employee status?
And when we do this, Lori, it's okay if people just go ahead and unmute, correct?
Sure.
You put questions in the chat if you want, everyone, but when we do these pauses, feel free to just unmute and go ahead and ask your question.
Yeah, feel free. And I'm not seeing the chat on my screen because I'm looking at the slides.
Yeah,
so.
I'll monitor that and I'll
Great.
make sure you're aware. But when we do these pauses, yeah, just feel free to unmute.
Great. Okay, I'm not hearing any questions right now, so I will move on, but feel free to let us know if you have a question. So let's revisit our scenario with Once Upon a Time. Cindy realizes that bringing Prince on as a contractor was probably a mistake, and they decide to hire him. So let's talk a little bit about the steps that you should take as you're hiring an employee. And we're going to talk a lot today about sort of the life cycle of an employee and the different stages of employment that you may have with various individuals. So what are the steps that you need to take when you're bringing an employee on board in your organization? First, of course, they would fill out an application for employment. And you should really think carefully as you're designing your application about what information you need to know about this individual in order for you to assess whether or not they would be a good fit for the organization. In both your application and the interview process in which you engage, you should focus on the job duties and whether the individual can perform those job duties, and not on personal characteristics of any individual who's coming in to interview with you. What you need to determine in that process is whether or not this individual is the best candidate to do the job. And so that's really where your focus should be. I typically advise clients that, particularly in a state like Georgia, which is an at-will state, and I'll explain what that means in a minute, you should use an offer letter and not an employment contract with employees. You're not employing them for a particular term, and giving them an employment contract typically gives someone a little bit more of a guarantee of employment than you have to give under Georgia law, or than you might want to give. At-will employment basically means that you can terminate an employee, or the employee can leave employment at any time and for any reason, with or without notice. That's what the Georgia at-will employment doctrine means. However, I do want you to be aware that there are some limits on your ability to terminate employment, and there are some best practices around it that you should be aware of. You cannot terminate someone's employment for an illegal reason, even though we're an at-will state. And so that means if your organization is subject to federal or state discrimination laws, you can't terminate someone in violation of those laws. It's also a very good practice, and we're going to talk about it much more later, to be sure that you're managing employee performance, and that you really don't terminate an employee with no reason. Because even from an employee relations standpoint and a best practice standpoint, that's really not the way that you want to treat people. But even with that being said, Georgia is an at-will state ultimately, and you have the right to terminate or to have an employee leave at any time. The next thing to think about in the hiring process is a confidentiality agreement. I'm sure that many, if not all, of the organizations on this call work with clients, and you have information about those clients that you keep in your organization. Some of that information is information that identifies those individuals, and you may have even more personal information if you provide services that relate to any kind of medical service, or if you need information about the individuals to determine their financial status, anything like that. And you probably have information as well about your volunteers, if you have volunteers who work with your organization, and certainly you have information about your donors. All of that information, in addition to information about your business and how you conduct it, might be confidential information that you want to ensure is kept confidential. And the best way to do that is to ensure that those who are working in your organization have signed a confidentiality agreement promising to keep that information confidential. So I think that's a very good thing to have as part of your hiring process, to make sure that employees understand their obligations with regard to confidentiality and that they have acknowledged those obligations. In addition, when you're screening individuals to come and work at your organization, typically, and especially if you're working with any kind of vulnerable population, you will want to have a background check done of those individuals. There are some very specific legal processes that need to be followed when you're conducting a background check. And they're outlined in something called the Fair Credit Reporting Act, and it's pretty complicated and certainly not intuitive to be able to comply with that law. It requires a separate acknowledgement of permission to conduct the background check. It has to be, if you're doing it on paper, it has to be a separate piece of paper. It can't be included in any other kind of acknowledgement that an applicant might sign. And it requires that you give certain notices to the individual before you take adverse action, like not hiring them because you found out about some conviction that's job related in their past history. So just bear in mind that there are specific procedures that need to be followed and that you might need some advice on how to comply with the Fair Credit Reporting Act if you're going to do background checks of employees. Also, please keep in mind that if you decide to do background checks through a vendor, the vendor may have processes that comply with the Fair Credit Reporting Act, but you will want to verify that because ultimately your organization will remain responsible for whatever use you make of that background check information, even if you're using a vendor. And at times I've certainly come across situations where a vendor did not comply properly with the Fair Credit Reporting Act requirements. And so the organization had to put its own processes in place to ensure that everybody jumped through the right hoops with regard to doing background checks. If you get information about a criminal conviction as part of a background check, you'll want to be sure that you're considering on a case-by-case basis whether that conviction information really is job related and should exclude someone from being hired or not. You shouldn't have sort of a blanket rule that says any criminal conviction will result in not hiring that individual. You really need to consider it on a case-by-case basis and look at what the person is being asked to do in the job for which you're hiring. And I should mention that before you do a background check, you should make a conditional offer of employment. So the person should get a conditional offer of employment, then you conduct the background check, and then you need to follow a certain process if there's something in the background check that might disqualify that person from being employed. And finally, with regard to your initial hiring process, once you bring someone on board, you need to follow appropriate immigration processes. And I'm not going to spend a lot of time getting into this, but you need to fill out an I-9 form or have the employee fill out an I-9 form for every employee that you hire. And if you have 11 or more employees in the state of Georgia, you're required to use E-Verify, which is an electronic system that determines whether or not someone is authorized to work in the United States. So please be sure you're aware of that if you have 11 or more employees, so more than 10 employees.
Lori, there's a couple questions if it's okay, I wanted to pose to you. One is a little bit on your last section and one is on this section. So okay. I'll just read that. One question, it had to do with contractors versus employees. If an IT person is a vendor who comes on site occasionally, do they get a 1099 or are they treated like other vendors, like paying your electric bill or the phone bill? And I guess the difference here is that
coming on site, yeah, if they're coming on site to provide services for you, in all likelihood, they are a contractor and you should have an agreement with them. And I believe that you would issue a 1099 to them. It's not just paying a bill for something that like your electric or your water, it's someone you're bringing in to perform a service for you.
Okay, thank you. And the other question is,
but your accountant can probably verify. I mean, I'm not a tax lawyer, so let me say that your accountant can verify what you need to do from a tax standpoint.
Okay. If it's a business versus an individual, does that make, like if the contract is with a business rather than an individual, does that make a difference?
Probably not. It just makes it clearer that the contractor status is appropriate if they have their own business and they're doing that for others. But as far as a 1099, that's something that you likely have to provide them, but I would verify that with my accountant.
Thank you.
Sure.
Thanks. And the other question, this has to do with the hiring and screening process. A key role in our organization is major gift fundraising. The personality of the individual as to suitability to the work is a key feature regarding fitness for the role. How do you manage that type of thing in screening applicants?
You manage it in the interview process by determining whether the person, when they interview with you, would be a good fit from a personality standpoint. But really what I'm saying is that you want to keep away from things like asking illegal questions. So you don't, in the interview process, you really want to keep it at a very professional level. You don't want to ask things like, you know, you don't want to ask too much about family because it could lead to illegal questions. You don't want to, you know, you don't want to talk about someone's race or religion or anything like that in your hiring process. So you really want to keep it to the job and the requirements of the job. And for example, if the requirements of the job, such as in a job like that, a major donor liaison, you would want to ask things like a hypothetical situation where someone is dealing with a major donor and there's something challenging that happens. And then how does the person address it? You know, you want to get at it that way rather than trying to get too much into their personal life or into things that could lead to illegal inquiries. So hopefully that's helpful.
Thank you.
Sure. Okay. In continuing our discussion of hiring and when you bring on employees, of course, if you have an employee handbook, when you bring someone on, you'll want them to sign the acknowledgement to your employee handbook. And it is important to have appropriate employment policies. I'm not going to get into this too much today, but you certainly want to have policies that address things like appropriate conduct in the workplace, prohibiting harassment and discrimination in the workplace, and giving employees information about how and where and when to raise concerns if they have any concerns in the workplace. And your handbook is a good place to do that. You want to be sure to share benefit information and tax documents, of course, with your new employees. I often get a question from nonprofits about a probationary period and whether we should have a probationary or introductory period with new employees when they start employment with the organization. And it's certainly something that you have the right to do and you can do. What I want you to know really about probationary periods is that there's no specific magic to them. Putting someone in a probationary or introductory period so that they can get to know the organization can get to know them, is not something that sort of relieves you of the obligation to manage their performance if you have a performance issue. You still need to document performance issues and manage them. You need to issue discipline or warnings if they're doing something that's inappropriate in the workplace. Because it doesn't, you know, you don't necessarily, you can't necessarily terminate someone's employment during a probationary period with no communication or information. And then be able to comply with things like defending an unemployment claim where there was a performance issue. So, and we'll talk about that more later as well. But do be aware that you can do that, but it doesn't give you any special protection. With regard to personnel files, I just wanted to let you know that there are laws that regulate what you can and can't put in a personnel file. You should keep general employment documents in your personnel file, but you should separate out any medical information into a separate medical file. The Americans with Disabilities Act requires you to do that, to keep medical information separate. And I would also recommend that you keep I-9 information separate from your personnel file. And the reason to do that is because at times the Immigration Service comes in and audits employer I-9s. And if you should ever be subject to an audit, and I hope that you never are, you don't really want to hand them all your personnel files. What you want to do is have a separate file that has all of your I-9s in it, and that's all that you would give them if you were audited. And you know, the other reason to keep personnel files to just general employment documents is if there is any dispute with an employee and you receive a request for documents, often they will ask for your personnel file, and that would be all you'd have to produce. So just bear in mind that I-9s, medical files, and the other category that I would keep separately is investigative files. If there's an incident in the workplace and you investigate it, and you have documents related to your investigation or interviews or anything like that, you should keep that file separate from the personnel file of the individual. So I think that's not really intuitive. So something I like to mention to my clients. Workers' compensation and unemployment are obligations that you are required to comply with at a certain point in Georgia. With regard to workers' compensation, if you have 3 or more employees, you are required to have workers' compensation coverage in Georgia. Bear in mind that in counting the 3 or more employees, excuse me, it includes both paid staff and corporate officers, but up to 5 corporate officers can opt out, and they have to file a form with the Department of Labor to do so. So when you reach that threshold, just bear that in mind. It is important to have workers' compensation coverage because if you don't have it, you don't get the benefit of having workers' compensation be the exclusive remedy available to your employees if someone is injured in the workplace. And what that means is that an employee who's injured could go file a lawsuit against the organization if you don't have workers' compensation coverage. If you do have it, then they don't have the ability to do that. They have to make a claim through the workers' compensation. And finally, unemployment is required in Georgia if you have 4 or more employees in 20 weeks in any calendar year. And it includes 1 officer or director, even if they're not an employee. So technically, if you have an officer or director and 3 employees, you're covered by the unemployment requirements. And as soon as you have 1 employee in Georgia, you're required to register with the Department of Labor. So just keep those requirements in mind as you're increasing the size of your workforce. Because of the current presence of COVID in the workplace, I wanted to spend a few minutes just talking a little bit about COVID. And when you're hiring employees, one of the things that you think about and determine is where the employee will be working. And please be aware that since we have entered into the pandemic, many employers, I'm sure including many of you on this webcast, have instituted safety protocols, have instituted teleworking, which some may never have had before, and other policies and practices that differ from how we've traditionally operated our workplaces. So one thing to think about is if you're in the organization's facility, have you put appropriate safety protocols in place? And if you're teleworking, have you adopted policies to be able to facilitate that telework? You need to look at what the CDC is recommending with regard to safety protocols. And they have the CDC, the Georgia Department of Health, and the Occupational Safety and Health Administration, which you might hear referred to as OSHA, have guidelines in place for helping you to put appropriate procedures in place in your workplace. They address a lot of the things on the screen there: hand washing, cleaning surfaces, masks, personal protective equipment, social distancing, and screening. And so really give some consideration to the protocols that you're putting in place. You are permitted under the law to ask employees or others who are entering into your facility whether they have symptoms, and you are allowed to take their temperature, which I'm sure you've all figured out from going out almost anywhere these days, before they come into your office. Even if you're covered by the Americans with Disabilities Act or the Rehabilitation Act, the ADA comes into play if you have 15 or more employees, and the Rehabilitation Act covers federal government contractors. Those are laws that prohibit discrimination based on disabilities, but even under those laws, inquiries about COVID-19 have been deemed to be part of addressing a direct threat in the workplace. And that's why you can ask medical questions and take people's temperatures. And if you have someone who has exhibited symptoms, then you should require them to stay home, and you are well within your rights to do so. I don't have a lot of time to address vaccines and whether or not to mandate them. We have a very comprehensive article, which I've put a link to, and when you receive the the webcast slides, you'll be able to click on that link and look at the article. But there are a number of things that you need to think through as an employer in determining whether or not to mandate vaccines for your employees. And it's pretty complicated. You have the option to mandate them, but whether or not you should really depends on the kind of workplace that you are and whether or not it's something that, that you're willing to enforce. So really think carefully about what you want to do in your workplace. Be aware that there are legally required exceptions to people taking the vaccine. So there are certain groups of people that cannot be required to take a vaccine. Think about how you're going to enforce a policy, what's going to happen if an employee refuses to take it. Think about the confidentiality concerns that mandating a vaccine might raise. And the other consideration is whether or not you may have to pay employees for the time that they take to take a vaccine if you mandate it. But please take a look at that article and think through the issues if you're considering mandating vaccines in your workplace. If employees are working from home, think about how you're tracking their hours, what equipment they need to do the work, how you're protecting confidential information, and whether you need to put a policy in place to address teleworking. And also finally, make sure that you have a plan for what's going to happen if someone in your workplace has been exposed or has a positive test. I mean, I know we're pretty far into this, so you may already have planned for this, but please be aware that while you can share general information about someone in the workplace having tested positive or been exposed so that others understand whether or not they've had a potential exposure, you do need to maintain the confidentiality of specific information about any specific individual. So don't disclose any names of anyone who may have been exposed, even if you're telling folks in the workplace that there has been an exposure. And again, there are lots of resources on our website about a whole variety of issues related to COVID-19. We have a whole page of our website with lists of articles and webcasts and information about the many legal developments that have occurred as a result of COVID-19. So please do feel free to go there and take a look at the information that we've posted. And let me stop for a minute there and see if anybody has any questions.
I have a question about personnel files.
Yes.
Well, really two. Is a person allowed to look through their personnel file, and also are they allowed to make copies of what's in their personnel file?
There's no legal requirement in Georgia to allow an employee to look at their personnel file or to make copies. So it is really your choice whether you allow that. The only circumstance in which you're required to disclose a personnel file is if you receive a subpoena or a court order for that file. So no, you're not legally required to give an employee access to their personnel file. But on the other hand, there really shouldn't be anything in the personnel file that the employee is not aware of. So to give an employee access, from an employee relations standpoint, might not be, a problem, but it's certainly something you can decide from a policy standpoint. I would not necessarily recommend that you allow people to make copies of their personnel file, but to look at it is something different. Does that answer your question? Okay, I'm going to assume it does. Any other questions? Okay. Okay, well, let's talk a little bit more about Once Upon a Time and what happens next. So one day, Anna calls Prince and asks him to go to one of the organization's facilities with her to help her supervise some volunteers who are doing some work there. He agrees to go, but he knows that money is a little tight for the organization. So he says he's going to volunteer to do this work instead of getting paid. Anna says, that's great. Thank you so much for your willingness to give that to our organization. And she says, I'll just give you some money for gas when you pick me up. to take me to that facility. So there are several concerns that are raised by this situation. One of which is that Prince is agreeing to do work without being paid. And unfortunately, if someone is an employee of the organization and they're doing work that is the same or similar to the work that they did as an employee, they cannot do it for free. Remember that an employee is someone who you have suffered or permitted to work. So if you're allowing Prince to do work with the organization, you have to pay him for that work. When can an employee volunteer? An employee can volunteer, obviously, if the services are being performed for your nonprofit organization. If there is no coercion or pressure on the employee to perform the volunteer work, and the work is not the same kind of work that's performed by the individual in their regular day-to-day work. It has to be completely unrelated to the work that they normally do. And so you really need to be careful. If you ask an employee to do volunteer work for the organization, that could be viewed as coercing them. It really has to be voluntary. They have to step up and do it basically without being asked and without being expected to do it. So my rule of thumb really is that there are very few, if any, circumstances where it's appropriate to ask an employee or to have an employee volunteer for the organization for which they work. And so you really need to be careful when you're having an employee volunteer and make sure that it's completely voluntary and unrelated to what they do for you. But can we use volunteers? Of course, a nonprofit can use volunteers in the workplace. The volunteer is not supposed to replace your paid staff. And it's a good idea with your volunteers to have an agreement that recognizes their status of volunteers, that specifically indicates that they have no expectation of being paid, and that waives any potential liability for the activities that they're doing in your workplace. You might need to do a background check on volunteers, particularly if you're working with vulnerable populations, like working with children or working with the elderly or working with disabled individuals. And you should never pay volunteers. Anytime that you pay volunteers, you run the risk that they're going to be seen as an employee and not a volunteer. And then there could be an issue of whether you're paying them enough or whether you've paid for all the hours that they work. So please be aware that you really need to treat your volunteers as volunteers. And I know that a question that comes up a lot with our clients is, how do you recognize volunteers if you can't give them a financial recognition of any kind? And it's really a much better idea to recognize them in different ways. I would not recommend giving a volunteer a gift card, because that's really just handing them cash. You can pay expenses. Do keep that in mind. You can pay expenses for a volunteer, but you shouldn't just give them money. You can have a nice event and serve them lunch. You can give them a plaque or write them a nice letter, but don't pay them cash. Any questions about volunteers or using employees to volunteer? Okay, a little more information about Once Upon a Time. Excuse me. The day that Prince is supposed to work with Anna falls on a Friday, which is not a regular work day for Anna. She has already worked 40 hours this week because there was a volunteer reception on Tuesday night, and she worked late on Monday and Tuesday to get ready and attend the event. She decides to go with Prince, and she's going to spend about 5 hours at the facility with him. Cindy, who's the executive director, does not know that Anna is working that Friday. And I think there are a couple of issues here. First, Anna has worked more than 40 hours. So does the organization owe Anna overtime for the time that she spends working with Prince? And the second thing is she's going to be working more than 40 hours, but Cindy, the executive director, doesn't know that she's working and isn't aware that there might be an overtime obligation that's being incurred by this employee. Now, please be aware that anytime an employee works overtime, the organization is obligated to pay for that overtime, even if the overtime was not authorized by the organization. But what you can do if an employee works unauthorized overtime is you can subject that employee to your disciplinary practices. So Cindy could choose to issue a warning, a verbal warning or a written warning to Anna because of the fact that she worked without permission. But she still has to pay her for the 5 extra hours that she worked, which brings me to a discussion of the Fair Labor Standards Act.
Lori.
The Labor Standards Act is the law that requires employers to pay a minimum wage and overtime to employees in the workplace. So right now, the national minimum wage, which also applies in Georgia because Georgia doesn't have a contrary rule, is $7.25 per hour. And overtime is required to be paid at the rate of 1.5 times the employee's regular rate for all hours that are worked over 40 in a work week. Employers are required to maintain accurate and complete time records for their employees. And the only employees whose work is not subject to these rules are employees who are exempt under the Fair Labor Standards Act. Please do be aware that the Biden administration is discussing raising the minimum wage, and they're talking about raising it to $15 per hour. It has obviously not been implemented yet, but that is something to keep an eye on, that there may very well be an increase in the minimum wage going forward. I do want to talk a little bit about the exemptions to the Fair Labor Standards Act requirements. Only employees who fall into the specific exemptions are not required to be paid overtime when they work more than 40 hours in a work week. And there are quite a few exemptions under the Fair Labor Standards Act. They're very specific. And I'm going to talk about a few of them that we commonly see with our clients. So there are exemptions for executives, administrative employees, and I'll explain that one in a minute, and professionals. And I'm not going to talk about outside sales, but that's another exemption. The regulations give a lot of detail about these exemptions. To fit into an exemption, the individual position has to satisfy all 3 factors of the test for exemption. That the individual has to be paid a salary. That salary has to be at least $684 a week or $35,568 a year. I know those are kind of odd numbers, but that was part of a compromise that was reached when this number was increased a few years ago. And in addition, the individual's position has to satisfy the duties for the particular exemption. So let me talk about each of the exemptions that I think could have any applicability in most nonprofit organizations. The first one is the executive exemption. The primary duty of the person who satisfies the executive exemption is managing the entire organization or a recognized department or division. They have to supervise at least 2 full-time employee equivalents. So, it could be 4 part-time employees that all add up to 80 hours. But they have to actually supervise at least 2 full-time equivalents. And they have to have the authority to hire, fire, or change the status of those individuals. So typically in the nonprofit organizations that we see, your executive director might fit into this exemption, if they supervise enough people. You may have a department head, someone who manages a department of your organization who fits into this exemption. But it's pretty rare to see a lot of people who fit into this exemption in any nonprofit organization. Please be aware that if the position only supervises volunteers, that does not count. They have to supervise employees to fall within this exemption. The second exemption, and this one causes a lot of confusion, mostly because the name of it is really not an accurate description of what it covers. They call it the administrative exemption, but it's really not related to what we typically think of as administrative employees. A person who fits into this exemption would be someone who is at sort of a high policy making level within the organization. They have to perform office or non-manual work that's directly related to the management or general business operations of the organization. And they have to exercise discretion and independent judgment on significant matters. So someone who is implementing your curriculum would not fit into this exemption. Someone who is developing your curriculum might fit into this exemption if they have the authority to change it. Someone who is managing a function related to your business, like finance, might fit into this exemption. But your bookkeeper probably wouldn't fit into this exemption. It really has to be a high level position. And it causes a lot of confusion in the community. So please be sure to get advice on whether or not an individual fits into this exemption if you think that they do. One other thing to keep in mind is that the Department of Labor doesn't just look at job descriptions when it's determining whether you've done this correctly. They look at what the person is actually doing. So you really need to factor that into any analysis of whether or not someone fits into the exemption. The third exemption that we see at times in nonprofit organizations is the professional exemption. And for this exemption, the primary duty of the individual is working in a field of advanced knowledge or working in an area of invention or imagination or talent. So it can be learned or creative, or learned or creative. And so this would really be someone who has a higher degree of education and someone who is in a professional field. It typically applies to lawyers, doctors. It could apply to nurses. It can apply to, sometimes it applies to therapists if they're degreed, but it does not generally apply in that area. So you really need to be careful about who you apply this one to as well. It may not be obvious or clear who fits in to these different exemptions. And so please seek legal assistance. And please also be aware that it's not as simple as whether someone is salaried or hourly in determining whether they're exempt or non-exempt. You can be salaried and still be non-exempt. So only a few categories of employees qualify to fit underneath these exemptions. So be careful. And as I think I mentioned, there are consequences for failing to classify individuals correctly as exempt or non-exempt. Even nonprofits get sued for failure to pay overtime and then have to demonstrate that someone has not been misclassified. So if you classify someone as exempt and they should have been paid overtime, you can really incur significant damages and costs for the organization. And it's very important that you keep accurate time records so that you know whether employees are working overtime or not. So just to summarize, are employees entitled to overtime pay? There are significant risks in failing to comply with the Fair Labor Standards Act. Most employees are non-exempt. So it's always safer to treat an employee as non-exempt if you're not sure. Employees have to be paid overtime for every hour over 40 in a work week. They have to be paid minimum wage. And as I said, you need to keep accurate time records. You can enforce your rules so that employees don't work over 40 hours in a week without permission. But as I said, please be sure that you're paying them if they do violate the rule, but just managing their performance. And if you have, when you have employees keep time records, either electronically or by paper means, it's a good idea to be sure that they acknowledge in some way when they submit their time that it's accurate and complete. That will be helpful for you if you ever have to prove how much time an employee worked. So get help to classify correctly. Make sure you're paying attention to the distinctions between exempt and non-exempt employees, that you're keeping accurate time records, that you don't allow unauthorized overtime, and that you compensate employees for all the time worked.
Sorry, we have a few questions in the chat. I'll just read them. Okay. And others might have it directly. I think this one you answered. It said, can a nonprofit make you go home so you don't work more than 40 hours? It sounds like you can establish a policy.
Yeah, the answer is yes. Mm-hmm.
And yes, you can adjust. The other one was, can you adjust their work schedule to compensate for working over 40 hours? That was Rick Dunn. I want to make sure. Can you adjust their work schedule to compensate for working over 40 hours?
That's a great question. And I get it all the time because there's something that people call comp time, which really is a concept that doesn't exist in the law. You're really not allowed to do comp time with non-exempt employees. What you can do is you can adjust an employee's schedule within the same work week to ensure that they don't work over 40 hours, but you can't give them time in a later week to compensate them for having worked overtime. Once they work that overtime, you owe them pay for that particular week. And so you can't say, you know, you worked 5 hours extra this week, so next week we'll give you 5 hours off.
Okay, and so I think the next question was the same. It said, can a nonprofit trade authorized overtime hour for hour, or does it have to be 1.5 times the pay rate? I think that that's getting at the same thing. But if I'm not, that was from Amani. If you want to unmute Amani and make sure that I'm explaining your question correctly. And Amani had another question. What are the penalties for not complying with FLSA? It sounds like those can vary, right? Yeah,
well, the penalties would be, you know, you could be on the hook for, if someone filed a lawsuit for unpaid overtime wages, the damages would be the unpaid back pay, the back wages, penalties and interest. And then of course the costs of the lawsuit. So it can be extremely costly to fail to comply with this.
Okay. So I'll stop if anyone wants to unmute and ask a question, but also Lori, just to let you know, we're at 9:35.
Yes.
So, you know, we're building in a lot of questions, so we may not need a whole 15 minutes Q&A at the end. So we've got 25 minutes.
Great. Okay. Okay, well, I will go ahead and move on, but go ahead and put your questions in the chat if you have any additional questions. So principal employee now for several, oh, yeah, sorry.
One more that came in, I had to scroll down.
Go ahead.
Can you require exempt employees to track their time, not for payment purposes, but for knowledge of how much time tasks take, understanding of their workload, is their workload manageable? So it's more trying to see if what you're asking them to do is reasonable in the time they're being expected to do it.
Yes, and you can, it's just not legally required that you have exempt employees track their time, but certainly we do have clients who do that, and often they do it for grant compliance and other reasons, because you need to know how much time someone is spending on particular tasks, or just to manage their time and, you know, the resources that you're allocating. So you certainly can track time for all your employees, but you're only legally required to do it for non-exempt employees.
Great, thank you. Okay, that's all I have.
Okay, great, thanks, Tony. Okay, well, let's go back to Once Upon a Time. Prince has been employed for several months now, and Cindy has received some complaints about the quality of the work he's doing from volunteers. She's concerned that he's not scheduling volunteers properly, and she's going to terminate his employment. Any issues? Well, I would say yes. There are some issues with terminating his employment just based on the fact that she's heard some complaints. Presumably, Cindy hasn't done anything yet to manage his performance. And so it's extremely important that you manage the performance of employees and document any performance issues before you consider terminating an employee's employment. So a good performance review enables growth for the employee and for the employer. It should be provided in writing, it should be communicated to the employee, and it should provide accurate and timely feedback to the employee. In addition, if necessary, and hopefully it will never be necessary, it can serve as evidence to prevent or defend against any kind of employment litigation that might be filed against the organization. So it's extremely important that you provide regular performance reviews to document expectations, to document actual performance, and to evaluate an employee's performance. Let me give you a little bit more information. I'm not going to delve deeply into this right now because we're running out of time, but be sure you're well prepared, be honest in the feedback that you provide to employees, be consistent in how you treat individuals when you're giving feedback to them. Follow your organization's disciplinary policies. So a performance review is not the only time that you should be giving feedback to an employee. If there's any issue in the workplace or misconduct or poor performance, like what we have here with Prince, you should be sure to issue appropriate warnings. If you issue a verbal warning, you should still document it. Just because it's a verbal warning doesn't mean that it isn't something that you should have recorded in a document. And make sure that when you issue warnings to employees for disciplinary reasons, whether it's performance or misconduct or any other reason, that it's very clear and included in the document that further violations could result in termination of employment. The Department of Labor, when evaluating unemployment claims, looks for that statement, looks for the fact that the employee has been previously warned that continued poor performance could result in termination of employment. So make sure those words are on the warning document and allow an employee time to improve their performance. If the Department of Labor thinks you've been unreasonable in trying to manage performance issues, they will allow unemployment to be paid. And document all of the steps that you take with regard to performance. If you're contemplating separating an employee from employment, if the separation is for performance reasons, you should verify that you have appropriate documentation to back up the reasons for the termination, and that you ensure, as I just mentioned, that the employee has been warned about the possibility of termination of his or her employment. Be honest when you're delivering the news about the termination. Be professional, and there's no need to apologize. You know, just state the facts to the employee. When you're documenting a separation from employment, there are a number of things you need to think about and consider when you're terminating someone's employment. First of all, the Georgia Department of Labor requires that anyone who's separating from employment be provided with a separation notice. This is the document that the employee would take to the Department of Labor to file for unemployment, but the DOL rules require it be given to anyone who's separating from employment for any reason. You should consider whether you want to do an exit interview. And an exit interview would be an opportunity to talk to the employee about their experience as an employee, to allow them to express any concerns that they have, and to just manage an orderly departure from the organization. Make sure you consider whether the individual has any organization property, keys, laptops, documents. Do they have access to important accounts? You know, do they have access to your bank account? Do they have passwords? Make sure you get that information back and that you cut off access to any confidential information or accounts at the time that the person leaves. Think about when the final paycheck will be issued. Is it by the next payday? Does the person have accrued but unused vacation or paid time off? Under Georgia law, you're not required to pay out accrued vacation or paid time off unless you have a policy or practice under which you've done that in your organization. It's not a legal requirement that you pay it out, but if you have a policy that says you will, then you have to. If you have previously paid it out to employees when they leave, you also have to pay that out when they leave. Think about what happens to any benefits that the individual may have. If you have more than 20 employees and your employees have health insurance, you're obligated to give them continuation of their health insurance under COBRA. And you need to think about whether there's information you have to share with employees about converting any coverages they may have, like medical coverage or retirement benefit, to a personal coverage or account where they start paying for it themselves. So those are all things to think about when you're terminating employment. The termination shouldn't be a complete surprise to the employee if the termination is for performance reasons. They should know that there's been a performance issue. You should have a record of the disciplinary history of that individual and make sure you have a factual basis to support the termination when you carry it out. One other thing to think about when you're terminating employment, and this comes into play not only if it's a performance-based termination, but also if you're terminating for lack of work or a loss of funding, anything like that. Think about the risk that that person might file a lawsuit. And this is also, it's a good thing to consult with your attorney about. You might not want to try to make this decision yourself. Think about the type of documentation you have and whether that documentation is sufficient. If it's not sufficient, you either need to continue the process and continue to document the performance issues, or you need to consider whether you want to provide some kind of separation agreement with a release of legal claims and pay the employee something in exchange for signing that agreement. And the reason to do that would be if you think there's a risk that the employee might come back and try to file a lawsuit against the organization. Getting an agreement like that will help insulate the organization from liability and give you an opportunity to get the organization released from any potential legal claims. So that's something to think about when you're conducting a termination of employment. And again, I would be sure that you have an attorney draft that document for you. There are a lot of requirements that relate to what makes an enforceable release of legal claims. And so you want to make sure that you're doing that correctly and handling that correctly. Any questions about termination or separation from employment?
What is the Older Workers Benefit Protection Act?
The Older Workers Benefit Protection Act is a law, was an amendment to the Age Discrimination in Employment Act that has certain provisions that are required to be included in an enforceable release of legal claims under the Age Discrimination Act. So it requires things like notice of the opportunity to consult with an attorney. It requires you to give a specific number of days to consider whether or not to sign the agreement. And it requires you to give a revocation period to employees who sign a release of claims, during which they have the opportunity to revoke it. So it's some very technical requirements that relate to a release of Age Discrimination Act claims.
Okay, thank you.
Sure. Any other questions?
Nothing in the chat, and we're at 9:45.
Okay. Well, I will quickly go through the next scenario because I think it's important for you to hear some of this information, and then we can take some questions. The next thing that happened at Once Upon a Time was that Cindy decided to wait to terminate Prince's employment because she didn't have enough performance documentation. But one of the volunteers, Jasmine, approached Cindy and told Cindy that, Prince is usually very charming to her and maybe he's being a bit too charming. He's asked her out and she said no, and he seems to be persisting in pursuing her. She tells Cindy that she just wants to handle this issue herself. She doesn't want Cindy to do anything. And she'll talk to Prince again and see if she can get it resolved. What should Cindy do? Well, I want to be very clear that if any concern related to harassment or discrimination is raised within the organization has an obligation to investigate and address that concern. You cannot allow Jasmine to address this concern herself, whether it's an employee or a volunteer or anyone else in the organization raising the concern. You need to conduct an investigation and determine what's going on and determine whether any disciplinary action needs to be taken. And so, as I said, anytime something like this is raised, you need to conduct an investigation. You should also consider whether you need to separate employees from each other or suspend someone pending the investigation to make sure that you have removed any risk that inappropriate conduct is going to happen in the workplace. If you suspend someone pending an investigation, you should pay them. It should still be a paid suspension because you don't want to take action that could be viewed as retaliating against that employee before you've proven whether anything wrong was done. It may just be cautionary.
Lori, quick question.
Yeah.
In that scenario, would Cindy need to tell Jasmine right then, well, now that you've told me this, I need to move forward with an investigation so that she's aware? It's almost like being a mandated reporter. You're letting the person know this isn't going to happen, even over Jasmine's objection.
Yes, it's a good idea to communicate with the individual that you're going to conduct an investigation. And really, what you can do is tell her, look, Jasmine, now that you've brought this up to me, I have an obligation to take action to protect you. I can't just allow you to handle this yourself, but we will investigate in as confidential a manner as we can. Don't promise complete confidentiality because you can't achieve that, but we will be, we will keep this as confidential as we can. There will be people we need to talk to in the workplace, and there will be no retaliation against you for raising this concern. So those are the main things that you'll need to tell Jasmine as you go forward with the investigation. And, if you don't tell the person in that initial conversation, be sure that you get back to the person and tell them that after you've sort of figured out what it is that you need to do. And I'm not going to go through all of this, but you need to determine who the appropriate person is to lead your investigation. Keep in mind that it might be, it might be an employee, a high-level manager, the executive director, but it might also be a board member or an outside person, depending on who's raising the complaint, who the complaint is about, and what the nature of the complaint is. And make sure that person understands how to investigate concerns. A good investigator is someone who's neutral, someone who looks for facts and builds rapport with interviewees, and is prepared to handle any challenges that might come up in the investigation. When you're planning the investigation, you should think about who should be interviewed, in what order. You should be very well prepared and think about the questions that you want to ask. You should ensure that the people you're interviewing understand that they need to cooperate with the investigation, that you'll maintain confidentiality to the extent you can do so, and that nobody's going to be retaliated against for giving information as part of your investigation. And you should be sure to document the information that you find out in the investigation and keep that documentation. Never express an opinion or judgment in the course of the investigation. You do have to reach a conclusion at the end and make a decision, but don't express your own opinions as part of the investigation. Never write them in your notes. Be careful about not reaching legal conclusions. So for example, if you're investigating the issue with Prince, there's an allegation of sexual harassment. Your goal in the investigation is to determine whether there's been a violation of your sexual harassment policy, not whether there's been a legal violation and not whether or not sexual harassment has occurred. Don't reach that legal conclusion. The only conclusion you should reach is whether or not your policy prohibiting harassment has been violated or any other conduct rule that you might have. So really focus it on the organization's rules. And that's because if this ever went to court, you don't want a document out there that discusses the legal conclusion. And if you find that some misconduct had happened, you certainly don't want a document out there saying that Prince committed sexual harassment while he was working for your organization, because that creates risk for the organization. What you want is a document that says there was a violation of our harassment policy. So let's see, as you're reaching that conclusion, think about credibility of the witnesses, the documents that you have and information that you have, and then you'll have to reach a reasonable conclusion and determine what your steps are, what your follow-up should be. And here's some information about follow-up. Make sure you get back to the person who complained and the subject of the investigation to inform them that the investigation has been concluded. That doesn't mean that you're necessarily telling them all the details of what's going to be done. That might be confidential, particularly if you're taking disciplinary action. So you would not let the complainant know, if you decided that you have to issue a final written warning to Prince, you wouldn't let the complainant know that. You would just let the complainant know that action has been taken to address her concern. You need to implement any changes to policies or procedures. You need to take that corrective action. Think about whether any training might be needed as part of your corrective action, and then keep a written report of your investigation and keep it in your investigative file, just like we talked to earlier. Keep all those relevant documents in your investigative file. And I will stop there. I think we're about 5 of 10. And see if anyone has any questions that I can answer.
We've got 2 questions, and then I'll if people wanted to unmute afterwards. One is, what should a nonprofit executive director or board of director do if the complaint is related to a volunteer or a donor, not an employee? So if Prince was not an employee, if Prince was a volunteer or a donor, is it the same?
Yeah, basically it's the same thing. What you would do is investigate. You investigate the concern and then you figure out how to address it. And I understand that it's a little bit different if someone's a volunteer than if they're an employee, or particularly if someone is a donor, there may be some sensitive issues there. But you have an obligation under the law to protect the people who work for you and the people who volunteer from you from inappropriate conduct in your workplace. So you would have to conduct an investigation and then you would have to figure out what to do. With regard to a volunteer, you could take disciplinary action just like you would with an employee. And that could encompass things like limiting the kinds of volunteer services the person is allowed to do. It could involve terminating the volunteer relationship with the organization. It really depends on what you find in your investigation. And the same thing with the donor. You may have to take steps to make sure that whoever raised the concern is protected from interaction with that donor that might be appropriate in whatever way is appropriate to do that. So it doesn't really change the process.
Okay. The other question, going back to not making legal judgments, but how does one decide whether an issue should actually be reported to law enforcement?
Well, unless there's a violation, unless there's something that's a criminal violation, you typically would not report it to law enforcement. You would take action within your workplace. But if someone has stolen from you, if someone has assaulted someone or something like that, if you have a serious incident like that, you should probably call the police as soon as you're aware the incident occurred. If someone needs protection, then you should call the police. That's if there's something violent happening in your workplace, you're not going to worry at that moment about investigating. You're going to worry about keeping everyone safe. So certainly, if there's an emergency issue, you call 911 and then you worry about the investigation later.
Thank you. Just looking in the chat. I don't see any other questions in the chat. We've got 4 minutes left, and I know you wanted to just give some contact information, Lori. So if anyone has a question now, just unmute and go ahead and ask. We've got time for maybe 1 or 2 quick questions. All right, after the obligatory Zoom 7-second pause where we wait to see if someone, because it takes about that long to unmute and get your question out.
Right.
I guess, again, if anyone wants to put a final question in the chat, that's fine. If not, Lori, I would just want to give it back to you to go through. I know you had some contact info you wanted to give us.
Sure, and thank you all so much for your time and attention today. If you are interested in applying for our services, please go to our website, which you see right there on the screen, www.pbpatl.org, and you can feel free to fill out a request for legal assistance, and would love to see you do that. If you have any questions, you can feel free to email me after the session. And my email is Lori, Lori.Shapiro. Sorry, it's not on the slide. I should have put it on there. SHAPIRO @pbpatl.org, just like the website address. So please feel free to contact me if you have questions. Please be aware that unless you're a client of Pro Bono Partnership of Atlanta, I can't answer specific questions to give you legal advice. I can only do that if you're a client. So thank you very much for your time.
Well, thank you, Lori, so much. And there's the chats being filled with comments about how helpful this was and given us a lot to think about. So as well as the actual content and the information. So thank you again to everyone for attending. Thank you, Lori, for presenting. Sarah, Mark, or Josh, or Melinda, anything you wanted to add at the end? You saw in the chat, everyone will have the recording up on the website, and then we can get the slides out to you as well. So again, have a great day, everyone. Thank you so much, Lori, and enjoy the weekend. If your weekend's starting yet, or at least maybe in 6 or 7 hours.
Thank you, Tony. Thanks, everybody. Bye-bye.
Thank you.